Good morning, good afternoon, good evening, everybody. Thank you all for joining today. My name is Aditi Shetty, and I'm a researcher in international environmental law and climate change law at the British Institute for International and Comparative Law. Today's panel that I'll be chairing is the role of non-state actors in combating climate change. We will be embarking on a journey through the critical intersection of global governance, environmental justice, and climate action. Our discussion will unfold in two chapters today, shedding light on the pressing challenges and innovative strategies in pursuit of a sustainable future. We originally had 4 panelists, but unfortunately today 2 of them cannot join us because they are not keeping well. So this session might also close a little early, and everyone can go on their coffee breaks or lunch breaks or whatever breaks they need before you join back at 2 p.m. UK time. So with any further ado, I would introduce the speakers today. Our first speaker will be Dr. Egosa Ekator. He's a senior lecturer at the University of Derby in the UK and will be talking about the role of NGOs in regulating the activities of multinational corporations in Africa from the perspective of regional and sub-regional courts. He will be highlighting the absence of a global framework that regulates cross-border activities of MNCs, and then go into the discussion by discussing the victims and the challenges victims face to strive for environmental justice, and often turn to foreign jurisdictions, including the home states of MNCs and international courts. He will also discuss and focus on the cases filed by NGOs in the regional jurisdictions of Africa, especially the ECOWAS and the African Commission on Human and People's Rights. Our second speaker will be Sio Bao, who is a doctoral candidate at UCL London, and she will be talking about involving non-state actors in the implementation of climate provisions under the free trade agreement and from a contextual theoretical framework perspective. She will also explore the proliferation of climate provisions in free trade agreements and the debates over the effectiveness. While doing so, she recognizes the challenges of identifying relevant NSAs or non-state actors and bridging the gaps through a contextual framework for understanding NSA involvement and in implementing the FTA's climate provisions. I will not take up too much time, even though we have some spare time in this panel, and I will give the floor to Dr. Egosa at the moment.
Okay. Hello, good afternoon. Thank you. Can you hear me, please?
Yes, we can hear you.
I didn't know I was going to be the first presenter, so it's...
yeah, I am sorry about that. Dr. Laura Mai, she said that she's unwell and she can't be joining us today. So
okay, I'll just share my slides, so that's okay. So how many minutes for the presentation? How many minutes do we have? 15 or 20 minutes?
You can take 20 minutes or 20 minutes now, and then we can keep some time for discussion later on and question answers.
Okay, thank you. Can you see my slides?
Yes, we can.
Yeah. Good afternoon, everybody. My name is Egosa Ekator. I'm a senior lecturer at the University of Derby Law School. So my research is basically around international environmental law with focus on environmental justice in developing countries. And I've also done stuff on natural resource governance. So For today's topic is a paper I'm working on, so I'll be very grateful if I can get feedback. So the title of my paper is the role of NGOs regulating activities of MNCs, perspectives from regional and sub-regional courts. So the initial idea for this paper was to discuss relevant case law from the ECOWAS Court of Justice and the African Court of Human and People's Rights and the African Commission as well. But I'm going to focus solely on the ECOWAS Court of Justice because of time, and that's so. For my discussion for today, I'll discuss the. My outline is about first discussion about NGOs international law. What is the role of NGO? Do NGOs play any role in international law? Are NGOs can NGOs be seen as subjects of international? Some are some of the topics I'm going to discuss. Then, in terms of the second slant of my discussion is the role of multinational corporations and international law as well. So, for example, MNCs are very powerful commercial slash corporate entities, and MNCs are not subject of international law. How can we regulate MNCs? Then, the third aspect of my presentation focus on NGOs in regulation. So, the idea is I'm trying to conceptualize if NGOs do have a role to play in regulation. So the idea is that regulation itself, in its context, is a broader definition of regulation, not necessarily state-centric or public regulation, but seeing how NGOs impact on regulation. So the key point for me is how I'm going to use the cases at the ECOWAS Court of Justice filed by NGOs to justify how NGOs can play a role in regulatory process. So in the context of this paper, regulation is defined broadly and not just as as what we understand to be public or state regulation or command and control regulation. So the fourth part focus on the role of NGOs in regulating activities of MNCs via litigation. To the focus on ECOWAS Court of Justice, which has had some very fantastic case law regarding access to environmental justice, regarding whether MNCs can sue or be sued at ECOWAS Court of Justice. I also suggest recommendations and conclusion. So the first part of my work talks just basically focus on NGOs and international law. So we understand that NGOs are not seen as main source of international law, but that doesn't mean that NGOs do not play a role in international law. Even NGOs like Amnesty, Transparency International, they do have a fundamental role that they play in international lawmaking. They might not be seen as service of international law, but they have a very effective, important, and integral role to international lawmaking. So if we look at Article 71 of the UN Charter, it states that the Economic and Social Council makes suitable arrangement for the consultation with NGOs which are concerned with matters within its competence. So, as I alluded earlier, NGOs are major players in the UN, especially in influencing the formation of treaties, conventions, providing expertise at the various international conventions and negotiations. And we can see the role of NGOs, especially the making of international environmental law, and even in development of the Paris Agreement. NGOs, civil society groups play a very important role by providing expertise to the various negotiating teams. Also, Professor Shadnovis talks about the importance of NGOs in international trade law, and it states that NGOs have fostered treaties, promoted the creation of new international organizations, and lobbied national capitals to gain consent to stronger international rules. So, from the perspective of global South, from countries for example, like like the USA, South Africa, and India, especially, environmental NGOs have played a very important role in expanding environmental local standard, in promoting access to environmental justice, in promoting right to environment, and a plethora of socio-economic and public interest litigation are basically done by NGOs. And also many of these cross-border foreign litigation instituted by Nigerian or African litigants in different foreign courts. Most of them are actually done by NGOs. So NGOs do have a very important role to play in different parts of the world. So it's beyond doubt that NGOs have contributed in the creation, development, and enforcement of international law. They've brought new ideas, sustained focus and pressure, and effective means of action in international law. So, as I alluded to before, the states are the main or perfect service for international law. The question is, with the way international law has evolved in the last 30, 40 years, can we actually say in reality that states are the only service of international law? Not even saying that non-state actors do play a role. I think the idea is that the framework of international law has gone beyond the state-centric Westphalian idea of international law. So non-state actors do have a very, very important role to play. And sometimes, and some scholars have said that non-state actors should actually be seen as proper subjects of international law. For example, Iloka basically argued that the international law system should be reconceptualized to explicitly include the contributions of other international and non-state actors. So, in concluding this part of the presentation, the view is that NGOs do play a very, very important role in making international law more responsive to the needs of the international community. So also NGOs play an important role in these various international mechanisms that have been developed to regulate or MNCs at the international level, or this idea about this global governance, international priority regulation, or transnational regulation. NGOs, civil society groups play a very, very important role. So, how do we define transnational regulation? Transnational regulation relies on guidelines, codes of conduct, standards issued by MNCs, multi-stakeholder initiatives, international organizations of all kinds, such as the Rainforest Alliance, the ISO 2600 Guidance on Social Responsibility, and the UN Guiding Principle, the ROGI principle. So NGOs do play a very, very important role at the international governance architecture. So in regarding MNCs are very, very powerful entities. MNCs are companies which operate in more than one companies which operate in more than one country. Currently, there's no standalone international treaty that regulate the activities of MNCs. So a lot of scholars have said that that means MNCs are operating in a legal vacuum because international law poses no direct obligations on corporations, and also many domestic in many domestic laws, it's very, very difficult to regulate the activities of MNCs and their subsidiaries. So a lot of people have said that MNCs are actually enjoying, basically taking advantage of the gray area in the regulatory framework regarding the activity. So there's a lacuna in international law has led to this permissive environment within which blameworthy act by corporations may occur without adequate sanction. This is very, very, very common from a global south perspective, where many MNCs have been accused of various environmental injustices, environmental degradation, violations of human rights, but it's very, very difficult to hold these MNCs accountable or to hold them responsible under domestic law. So this is one of the reasons why it's very important to regulate the activities of MNCs. So MNCs do not have like explicit legal status in international law. Some scholars have said that yes, notwithstanding, you can actually regulate MNCs through binding treaties that are directed at state but council made applicable to MNCs. This is what you do actually find under international investment law regime. Examples include bilateral agreement, multilateral agreements, and ILO convention etc. The other way you can actually that can be used to hold MNCs accountable under international legal system is the use of soft law voluntary mechanisms at the international level focused on the activities of MNCs. So, but the idea is that the existing framework is not explicit enough, it's not strong enough. So we need to be the international community needs to come together and develop an explicit framework to ensure that MNCs are regulated because MNCs, due to enormity and their economic powers, MNCs should be made source of international law. In a series of papers written by Professor Butler, he argues that MNCs are important across international law and MNCs have corporate commitment to international law, corporate keepers of international law, and that MNCs, in some instances, do act as de facto semi-states. Skashta also takes the same view that states may be declining in power, but the horizons of international law are going to expand. Yes, many MNCs are richer than many states in this world. Many MNCs do have are more powerful than some states within the state. Take the example of Nigeria, for example, the role of Shell. Shell has been a very, very powerful entity, and because of the FDI that many of these MNCs bring to developing countries, MNCs are very, very powerful. So that's why RINCC has gone on to say that at present, however, the obligations that corporations undertake at the international level remain voluntary. International law, for example, does not recognize international corporate crime. Notwithstanding this sort of gray area surrounding the regulatory framework on MNCs at international level, there have been rising cases at the national, domestic, international level, different jurisdictions where MNCs have been held culpable for human rights violations. A fairly recent case in Canada where the Nepson Resources Limited and Araya, where the Canadian Supreme Court held that MNCs can be held liable for human rights violations committed abroad based on customary international law. So there has also been a move by the international community to create an explicit business and human rights treaty to try and regulate the activities of MNCs. But if you look at the evolution of the creation of international treaties, the MNCs, international business community, have not been fully supportive of having a standalone treaty-based international framework on MNCs. For example, the UN norms was an attempt to do that in the past. Unfortunately, that wasn't successful. So a lot of people have said that there's no need to create a binding international treaty when the Ruggie principle already exists, that the Ruggie principle can do the role or do the function of a standalone treaty. But I think going forward, this current move to create the Business and Human Rights Treaty might be one of the ways to actually regulate MNCs at the international level. So now, how do we conceptualize the roles of NGOs? So ordinarily, traditionally, regulation is something which is done by government, which is done by the state, command and control. The state sets up, the state gives an instruction or develops a law, and if people, individuals, and legal persons violate this law, sanctions are attached to it. That means a command and control regulatory framework. So traditionally, regulation was done entirely in the domain of states, with states regulating businesses and economic activities in different parts of the world and country. So, however, this traditional notion of regulation is changing. So the traditional idea or the state-centric notion of regulation has been displaced by the idea of layered webs of regulatory influence by other actors, non-state actors in the regulatory process. So the idea is that not only states that can actually regulate, NGOs, agency, uh, uh, other agencies, IGOs can also play a role in regulation because especially in international environmental law or national environmental laws and policy, many parts of the world, for example, in the UK, environmental lawmaking is very, very fragmented. So you have command and control, you have market-based system, you have the use of agencies, etc. So in many parts of the world, environmental law is regulated by a plethora of actors, not necessarily or solely state actors only. So this idea of this different fragmentations of regulation is also akin to this theory of decentralized regulation, which means regulation has been decentralized, has been decentered from the state. That means the state is not only the main actor in the regulatory process. So, in that context, this paper, my presentation, takes a broader definition of regulation that explicitly includes the roles of NGOs in the regulatory process. So, the definition of regulation for me takes a broader perspective. That means NGOs do have a role to play at the domestic level, at the international level. So, and this present notion of regulation includes broader definitions that encompasses non-governmental forms of regulation and also supranational regulation. So my paper relies on the framework of regulation developed by Christopher Wood in 2001. So what did Wood and his colleagues say? They basically say that any analysis of regulatory regime brings to the fore two distinct connotations, but I'll focus on one connotation. So the first dimension or the first connotation that they allude to is that in any risk regulatory system or regime, it entails three components that form the base of any control system. That is ways of gathering, ways of settling standards, or goals or targets, and ways of changing behavior. So basically, according to Christopher Wood and his colleagues, in a regulatory regime, there are three dimensions: information gathering, standard setting, and behavior modification. These are the essential characteristics or the essential criteria for a regulatory system, especially state regulatory system. So, however, scholars including Otter Maoni, Black, Aquana, Ekato, myself, I've basically argued in some of my papers that NGOs can actually partake or contribute to the three components of the regulatory regime. So basically, if you look at the activities of NGOs, let's say from NGOs from a Niger Delta perspective, and look at what NGOs have been doing, we can actually localize the various activities of NGOs under these three subheadings of information gathering, standard agreement. I just give some little expansion on that. For example, in information gathering, NGOs the NGOs information can be used to conduct audits, can be used to gather information regarding the state of an industry. This is very, very pertinent in the oil and gas industry in Nigeria. For example, standard setting. Some NGOs have actually developed bills and laws that were passed to members of the National Assembly that were passed into law in Nigeria. For example, the Freedom of Information Act was a private member bill that was developed by a plethora of NGOs and civil society groups in Nigeria and was given to an NGO-friendly legislator in the Nigerian National Assembly, and that legislator was able to ensure that that bill was passed into law. So that shows that NGOs can actually be part of standard setting. Another example is when NGOs make rules and codes of conduct for the behavior of multinational corporations in the oil and gas industry as an example of standard setting. So the last one is behavior modification. Issues around protest, etc. is an example of behavior modification. And another important example of behavior modification is litigation. So NGOs activities can actually impact on the behavior of multinational corporations in society. So in many parts of the world where especially in the common law jurisdictions where when there is a final determination of a case, so when a matter goes to court, when the court gives a decision, the outcome of a decision can actually impact on the regulatory functions of the government. It can actually compel the government to change the law, or the government to amend the law, or the government to basically provide further amenities for the people. So now with litigation rather can be akin to regulation. I'll just give another example from Nigerian context. For a long time in Nigeria, right to environment was seen as not to be justiciable because the under Nigerian Constitution, Article 20, Section 20 of the Nigerian Constitution is found in no justiciable part of the Nigerian Constitution. So ordinarily, right to environment is neither enforceable or justiciable in Nigeria. However, in many of my publications, I've argued that on the basis of the African Charter on Human and People's Rights, which Nigeria has domesticated as part of its national laws, right to environment can be justiciable and enforceable in Nigeria. And also in Nigeria, many cases are instituted by NGOs dealing with environmental protection, but the issue of legal standard has been a very negative obstacle impeding on whether NGOs can institute cases in Nigeria to deal with environmental protection. So many of these cases have been struck out. So recently, in 2019, the Nigerian Supreme Court relied on 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 the African Charter on Human and People's Rights, relied on the Oil Pipelines Act, and right to life, which is an enforceable part of the Nigerian constitution, to hold that right to the environment can be enforceable and justiciable in Nigeria, and also that environmental NGOs do have the local standard, legal standard to institute cases on behalf of victims of oil degradation and oil pollution in Nigeria. So in that context, we can look at that decision as a regulatory tool. That decision is basically, if that decision is fully implemented and respected, that decision is going to change the regulatory behavior of governmental agencies for them to ensure that they stick and respect their regulatory functions and ensure that the oil spills is remediated ASAP, and also it should ensure that everybody and anybody in Nigeria is seen as an environmental and somebody who's an environmental stakeholder can institute cases on behalf on behalf of victims of environmental degradation. So from that perspective, litigation is a dimension, a very fundamental dimension of behavior modification. So litigation do have impact and can be seen to regulate the activities of MNC. So from that context, there are various cases that have been instituted by the NGOs, Nigerian NGOs in different parts of the world, including regional and sub-regional courts, and it can be seen as a tool. This litigation can be seen as a tool to regulate the activities of MNC. So in the previous paper, I've argued that behavior modification is perhaps the most potent strategy that NGOs have utilized in Nigeria to influence changing legal framework, including regulating the extractive industry. So, what does behavior modification means in the context of NGO influence? It refers to the avenues or strategies that NGOs utilize to spur public opinion in raising awareness and or support for a cause. Litigation is a key component of behavior modification strategies, which has been employed by NGOs in different parts of the world. So my previous paper also argued that litigation has now become a deliberate strategy employed by NGOs in their bid to influence the activities of the state and oil companies that operate in the oil industry. The rising number of cases filed both in Nigeria and abroad by or with the assistance of NGOs and indication of rising reliance on litigation. And because of the failings of the regulatory framework of the state or public regulatory framework in Nigeria and the oil sector, a lot of NGOs are going out of their way to ensure that the government MNCs do ensure that environmental degradation, right to environment, access to environmental justice should be protected and promoted. So now, what is the role of NGOs in regulating the activities of MNCs via litigation? The focus is on ECOWAS Court of Justice. So, because of the lack of justiciability of rights to environment in Nigeria, as I alluded to before, many NGOs have filed cases at the ECOWAS Court of Justice to improve access to environmental justice for victims in Nigeria. In the SERAP and federal government of Nigeria, it was 2012 because at the ECOWAS Court of Justice, a major issue at the preliminary stage of the case was whether ECOWAS Court of Justice has jurisdiction to pronounce on the responsibility and liability of the defendant corporation for alleged human rights violations alongside the state. The ECOWAS Court held that it has jurisdiction to hear a case brought by SERAP, which SERAP is an NGO in Nigeria, that SERAP has the requisite local standard to file the claim. However, the ECOWAS Court just said that only the Nigerian government and the NNPC, which used to be a state-owned oil company and plays an important role in the oil industry at the time, can be held accountable. That the MNCs uh, were originally added as parties to the case, were taking up the case. That it was only the Nigerian government and its agency that can be held accountable, liable for human rights violations in the Niger Delta. So the ECOWAS Court of Justice declined jurisdiction over oil MNC. So what was the reason for the ECOWAS Court decision? The reason was that under international law, only states and individuals in some cases can be held accountable, but companies cannot. So the court said that it does not have jurisdiction over oil MNCs because they are not parties to the ECOWAS treaties. So a major issue arising from this case was that there's a weakness in the ECOWAS Court of Justice framework is whether MNCs or companies can be parties of judicial proceedings. This is notwithstanding the broad wording of the supplementary protocol to the ECOWAS, which amending the ECOWAS Court of Justice, which amending the Constitution to grant access to individuals, corporations, and private parties. So, under the ECOWAS Court, individuals and private parties and NGOs and corporations, in some instances, can actually, especially corporations, individuals and private parties can file cases at the ECOWAS Court of Justice and NGOs. So, corporations, in some instances, can actually file cases at the ECOWAS Court of Justice. But the contention is whether you can sue, whether MNCs can be defendants at the ECOWAS Court of Justice. So, to the Insirap case, the ECOWAS Court of Justice said that as human rights treaties only impose obligation upon states, only states can be defendants to human rights claim before it. So a similar decision was made in Mormont case, where the courts also held that corporations are not subjects of international law, hence only states can be defendant in human rights cases under international law. However, there are divergent perspective and divergent academic and ECOWAS court decisions on whether MNCs or business entities can be parties in proceedings before the court and whether the ECOWAS Court of Justice is the appropriate court in the appropriate forum in this regard. There was a recent case that took place in July this year in the ECOWAS Court of Justice, the Argon Resources Limited against the Republic of Sierra Leone. In this case, the ECOWAS Court of Justice ordered the Republic of Sierra Leone to pay to $20,000 to a local company for interfering with its right to property. So Professor Nabulele, who's an expert on ECOWAS, was very, very critical of this decision. Why was he very critical? He says this decision goes against the tenor of the previous ECOWAS decision. So according to Professor Nabulele, it's a considered view that the court should re-examine the competence of corporation before it when it has opportunities. In our considered and respective view, the reasoning of the ECOWAS Court of Justice at this point is confusing, if not actually conflicting. The court cannot be here to say in one breath that corporations cannot proceed against the state in human rights matters under Article 10, paragraph C and D, and another breath, or that corporations could litigate certain exceptional human rights, certain exceptional rights before the court. Since this exception does not locate within Article 10, paragraph C and D, we are entitled to call upon the court to re-examine its position and provide appropriate clarity. Otherwise, it should invoke this jurisdiction to also overrule this aspect of the controversy and exclude corporations from human rights jurisdiction once and for all. So there are various perspectives whether the ECOWAS Court of Justice, under the ECOWAS Court of Justice, whether MNCs can be sued and MNCs can sue. So notwithstanding this decision by a critical decision in the Agom case, the ECOWAS Court of Justice can be a tool that can be used to regulate the activities of MNCs in Africa. We'll elaborate on that further. So on the other hand, according to Professor Kilanda, only states and ECOWAS institutions can be sued before the ECOWAS Court of Justice. So, in the context of the ECOWAS Court of Justice, I'll just quickly run through this. There have been very different perspectives whether the ECOWAS Court of Justice, MNCs can be sued at the ECOWAS Court of Justice. I'll just try and get this. Okay. Furthermore, there have been divergent perspective from whether this is from my article I wrote in 2022. Multinational corporations accountability and environmental justice to move towards regional litigation in Africa. So in this paper, I argue that MNCs can be sued and be sued under the ECOWAS Court of Justice. So there have been divergent views whether MNCs or business entities can be parties in prison for ECOWAS Court of Justice, and whether the ECOWAS Court of Justice is the appropriate forum. For example, scholars, including Ekato and Jane Wu, suggest that the corporational MNCs can be sued before the ECCG. I suggested that the ECOWAS decisions are also binding on individuals and corporate bodies, and therefore the ECOWAS Court of Justice can entertain claims by individuals and corporate claims for breach of their human rights. Arguably, this applies only to proceedings from examination of an action or inaction of committee official which violates the rights of individuals of corporate bodies. Kilanda takes a similar view, arguing that even though the ECOWAS of Justice in Ocean King Nigeria Limited against Senegal, that MNCs do not have local standard to bring cases of human rights violations, the ECCJ in Dexter, Oil, and Liberia case held that MNCs can bring cases relating to the rights of property, fair hearing, right to property, and freedom of expression and opinion. So there are contrary decisions of the ECOWAS Court. There are some ECOWAS Court decisions where the ECOWAS Court said MNCs can be sued and MNCs can sue. Recent ECOWAS Court decisions just basically say that MNCs can sue to ventilate their rights relating to fair hearing, like right to privacy, right to property, right to freedom of opinion, etc. And that is the sort of the prevailing view by the ECOWAS Court that yes, MNCs cannot be defendant, but in some instances, MNCs can actually sue to ventilate and protect their right. So furthermore, Jane O suggests that by virtue of the ECOWAS 2009 Supplementary Act on Investment, the ECCJ has jurisdiction over investors, which includes MNCs. Therefore, the ECOWAS Court of Justice can also be used to hold foreign investors accountable. This will also improve the emerging role of the ECOWAS Court of Justice as a strategy and opportunity to hold foreign MNCs accountable for the actions in the ECOWAS sub-region. On the other hand, Appod and Radovic point that due to the existing frameworks and case laws, investors and foreign MNCs cannot be sued for the ECOWAS Court of Justice. This implies that MNCs cannot be plaintiffs or defenders in ECCJ cases. Also, Professor Wieta takes the view that business entities or MNCs are completely excluded from the jurisdiction of the court. So they have divergent ECOWAS court decisions, divergent academic perspective, whether the ECOWAS Court of Justice whether the MNCs can sue or be sued under the ECOWAS Court of Justice. My view is that yes, they can sue because MNCs should not only MNCs can sue and be sued as well, but MNCs are basically taking advantage of the ECOWAS court system and using the ECOWAS courts of justice to get compensation from governmental agencies that have undermined or undermine right to property of MNCs in ECOWAS states. So on the other hand, when it comes to where MNCs are seen as defendant, MNCs will raise preliminary objection that they are not parties to the ECOWAS treaty, so they cannot be defended, but they enjoy the benefits of being able to sue at the ECOWAS Court of Justice. So another issue is whether
And sorry to interrupt, Dr. Ekator. Just wanted to being mindful of the time. It would be great if you could just wrap up soon, so we have enough time for CU to also speak up. So thank you.
Okay, thank you very much. So the view that ECOWAS Court of decisions cannot be implemented, but the Serap case, a lot of scholars believe that has not been implemented. But on the reality on the ground is that some of these cases have been actually been implemented. So the Serap case has had modest impacts on activities of environmental agencies in Nigeria. So governmental agencies actually are using the Serap case to guide the activities in Nigeria. So what are my recommendations? I suggest that the ECOWAS protocol should be explicitly amended to grant the court's jurisdiction over activities of MNCs in sub-region. African states should explicitly and fully implement the decision of the ECOWAS Court of Justice, and the ECOWAS Court of Justice should clarify the gray areas regarding whether MNCs can sue and be sued, so that all legal persons should have the ability to be sued and sue at the ECOWAS Court of Justice. So finally, my conclusion is that decisions of international courts in Africa are always relegated to the mainstream literature international law. Many sub-regional regional courts in Africa are at the forefront of groundbreaking decisions. This paper is in tandem with Ayodele Perry, who states that sub-regional and regional courts in Africa dispense distinctively African jurisprudence over African claims. So, however, the role of the ECOWAS Court of Justice and its impact on regulation of MNCs needs more critical evaluation. There's a role for the ECOWAS in regulating MNCs. So, finally, reliance on the ECOWAS of Justice is not the solution to the environmental degradation arising from the activities of MNCs and the political inertia of African state, but it provides an additional strategy that can be used to ensure that MNCs are held accountable for their misdeeds. So my view is that that's when you broadly define regulation, NGOs via litigation can play a role in regulating the activities of MNCs. So NGOs via litigation in various courts in Africa, especially the Court of Justice, can regulate the activities of MNCs in Africa. Thank you very much. I will appreciate comments as well. Thank you.
Thank you so much, Dr. Ekator. And this, I think, was very interesting, very detailed from a particular region and perspective. But moving on to the next one, I think this ties in very well from like a regional, from a bottom to a up approach, where as you would be talking about FTA frameworks and climate provisions. So, Theo, I give you the floor now.
Thank you very much. Let me share the handout now. Can you see it?
All
Perfect.
good.
Yeah. So good morning, good afternoon, and good evening, depending on where you are. And thank you very much to the chair Aditi for your introduction. And many thanks to the online audience for joining us today. I'm Mr. Yu Bao. I'm a PhD student with University College London Faculty of Laws. And I'm delighted to have the opportunity to be here and present my paper titled Involving Non-State Actors in Enhancing Compliance with FTA Climate Provisions, Theorization Through Contextual Lenses, which is a working draft of a chapter of my PhD thesis. So I'm personally not a big fan of colons in titles, and against this literary preference of mine, I've put together this title in the interest of information, as it does say a lot about the orientation, the scope, and the method of this paper. So the title defines the general inquiries that this paper engages with, which is the role of non-state actors in the implementation and enforcement of international law or compliance with international law. It also indicates what this paper is about and is not about. It is about a specific body of international rules, provisions that address climate change in free trade agreements and how non-state actors are associated with them. It is not about policymaking or treaty negotiation, meaning that FTA climate provisions are taken as given in their current formulation in this paper, and I explore if and how non-state actor involvement can aid in giving effect to these provisions. Finally, the title suggests the method or approach of this paper. The paper adopts a contextual approach, which involves two steps or two questions to ask. First, what do we need to consider generally in understanding non-state actor involvement in relation to international law compliance? And second, how do considerations in the present context, which is compliance with FTA climate provisions, inform non-state actor involvement to be conducted in a certain way? And allow me to start with the output of this paper, a set of normative arguments or resulting from the course of contextualization, which I term as hypothesis. Hypothesis 1 argues that non-state actor involvement should adopt a multi-stakeholder structure, inclusive of not only driving forces of climate action, but also opposing interests. Hypothesis 2 argues that non-state actor involvement serves various values, and it would be a serious misuse and underuse of it if we treat these actors as mere sources of technical expertise. Hypothesis 3 links the appropriate method of non-state actor involvement to different types of FTA climate provisions, and hypothesis 4 to 6 go on to specify a number of effectiveness conditions regarding different involvement mechanisms. Now let me jump back to the starting point of contextualization, the general framework. So on the subject of non-state actors and international law that is not limited to the specific area of compliance, there is extensive literature in both international law and international relations, including the framework on the regulatory regime or behavior modification that Dr. Agosa just mentioned in his presentation. So what this body of literature has agreed on is that non-state actor involvement should not be a binary concept, but rather a matter of extent and form. But what this corpus of literature has not been quite attentive to is that various processes in international law differ from each other in terms of what role non-state actors play therein. So most existing scholarship either on non-state actor involvement and international law either addresses international law generically or focuses on policymaking, but rarely considers international law compliance specifically. So building on this landscape of literature, I consider 3 elements to be relevant to the general framework. The first one is about stakeholders, so which non-state actors should be considered. It seems appropriate to suggest that the grounds for determining stakes or interests should vary with the nature of the issue area. So for instance, if an issue is global in nature, then interests should be perceived broadly, not confined to those specifically targeted by the concerned measure as the procedural laws of some domestic legal systems so interpret. If an issue suffers from collective action problems, then it seems natural to suggest that mission-driven non-state actors that promote the public good, such as non-governmental organizations, should be included. The second element is about values. So for what roles should non-state actors be involved? Arguments in existing literature are generally threefold, and one considered in light of international law compliance. We may say that non-state actors can supply specialist knowledge to interpret primary legal rules and characterize state practice. They may have informational and motivational advantages in monitoring non-compliance, and they could give voice to marginalized communities and expose questionable on-the-ground circumstances. The third element concerns the specific methods through which non-state actor involvement can achieve its values and contribute to international law compliance. Now, there are different means of compliance, some harder, like dispute settlement and monetary payments and retaliation, some softer that operates through pure reputational pressure. So for softer means of compliance, non-state actors can be direct suppliers of reputational pressure by naming and shaming states publicly and openly. This is what underlies the domestic advisory group's mechanisms under the present generation of EU FTA, specifically under their trade and sustainable development chapters, or at least what they're supposed to do. For harder means of compliance, non-state actors can initiate disputes directly against states in limited circumstances where private rights of action are granted. In other and perhaps more common cases, non-state actors' influence is largely limited to indirectly flagging potential violations for states to pick up and bring into the interstate system. So the so-called submissions on environmental enforcement matters mechanism under a number of EU FTAs, and more recently, the single entry point procedure established by the European Commission are representative examples of this method. So the classification of softer and harder means of compliance is mentioned here because it establishes a link between non-state actors' compliance enhancing methods and different substantive obligations. So while softer means of compliance are widely applicable regardless of the nature of obligations, harder means which relies on legally establishing a violation as a prerequisite would be difficult to invoke if the provision at hand imposes an aspirational obligation or has a rather onerous evidentiary burden. So compliance with the latter kind of provisions will therefore benefit more from non-state actors' direct pressuring as compared to indirect flagging. Now we turn to the context. So the concerned context I consider to be consisting of 3 layers. Most immediately, we have different legal formulation of substantive FTA climate provisions. Then we must look at the inter-regime linkage between international trade and climate change. And finally, most broadly, we have climate change in the background as a public policy issue. So let me start with substantive climate provisions in FTAs. So there is extensive research on these provisions in the present generation of EU FTAs, and less so in similar provisions concluded by other states and regions, notably by the United States. But generally speaking, the formulation of climate provisions in different FTAs do not show much variation. So there are, in general, 3 types of FTA climate provisions. First, floor provisions, which reaffirm parties' commitments to existing multilateral environmental agreements. And here, the most relevant ones are, of course, the UNFCCC and the Paris Agreement. Second, non-regression provisions, which prevent parties from lowering their levels of climate protection to exchange for economic benefits. And third, evolution provisions, which often use best endeavors terms and provide that parties shall strive to improve their future levels of climate protection. So it is widely recognized in academic writings that floor provisions and non-regression provisions are mandatory in nature and have less demanding evidentiary requirements, whereas evolution provisions are aspirational in nature and imprecise and vague in content and therefore difficult to implement. So following the connections made between non-state actors' compliance involvement methods and different substantive obligations under the general framework, these compliance-related aspects of substantive obligations hint at the proper methods of non-state actor involvement for each type of FTA climate provisions. And the second layer of context, the trade climate change linkage, is often considered in terms of their substantive interactions. In very, very simplistic terms, that trade can be both good and bad for addressing climate change. But what I'm more interested in here is the procedural aspects of this linkage, or namely, the implications that can be drawn from the very fact that climate change is addressed in the framework of FTAs. So I'd like to make 3 points here. First, procedures under FTAs can be regarded as patches to enable the monitoring of individual states' implementation of their climate commitments, which is currently not provided by the UNFCCC regime. So non-state actor involvement mechanisms as part of this complementary patching procedures should then be constructed with the aim to facilitate and achieve the value of monitoring, which in turn informs the design of, for example, rules on access criteria to evaluate non-state actor submissions and petitions, etc. Second, FTAs have an exposing effect on the impact that entrenched vested business interests often have on governmental decision-making. One might argue that the existence of this impact, this risk of capture, justifies denying access to this interest to non-state actor involvement mechanisms. But the absence of internal channels wouldn't stop these interests from utilizing external connections, and bargains happening behind the scenes are always harder to consider, to identify and control. I therefore argue that these bargains should be brought into the open, and the impact, the risk of capture of vested interests should be reined in through transparency and built-in procedural safeguards. This favors a multi-stakeholder model that is inclusive of not only classic driving forces of climate action, but also potential opposing business interests. Third, the present generation of FTAs often adopt what I call trade and X formula. So climate change is merely one of the intersecting non-trade issues in existing FTAs, and which makes inter-issue competition an inevitable concern. And in practice, mixed membership and issue areas have indeed resulted in competition between, in particular, labor and environmental considerations, as we can see from the example, the empirical example in the lower left corner. This shows that the specificity in participants and in subject matter should be taken into account when designing collective non-state actor involvement mechanisms. And regarding the broadest context, climate change as a public policy issue, I suppose no one today, or very few people, would deny that climate change is a challenge of global scale and an archetypal collective action problem. These features shed light on the scope of stakeholders in this issue area. They clearly favor a more expansive interpretation of interests and the inclusion of mission-driven actors, such as environmental NGOs. And climate change is also not only an environmental challenge. Socioeconomic and political considerations lie at its core. Chiara Armani and Maria Lee have argued in a recent article that the complexity of climate change resists technocratic solutions. So at the risk of oversimplifying their fantastic article, but in the interest of time, I'd simply say here that considering the complexity of climate change, especially the distributional effects resulting from climate change and from climate mitigation efforts, a governance model, or the hope that climate change can be addressed by involving only governments and experts working towards a clear, predefined policy objective is only a delusion. Now, the contextual analysis has led us to a set of normative arguments or hypotheses, which I have addressed at the outset of my presentation. There are a few points, such as hypothesis 6, that I didn't say much about given the time constraints, but I'd be happy to discuss in the Q&A. And before concluding, allow me to say a few words on the term hypothesis. So as I said, this is a working draft of a chapter of my PhD thesis, and I use this term, hypothesis, to show that the proposed normative arguments are meant to be tentative. So if we look at the practice of non-state actor involvement mechanisms under existing FTAs, it is not hard to spot quite a few departures from this proposed hypothesis. Hence, we have the question of whether these departures necessitate reforms of existing mechanisms, or instead do they require modifications to the proposed hypothesis. Moreover, a number of important perspectives are left unaddressed. For example, the overwhelming sense that many might have that democratic solutions are too inefficient while the climate crisis are too urgent and pressing, and how the proposed arguments would fare in light of the principle of common but differentiated responsibilities and respective capabilities. I consider responses to all these points to be more or less grounded in real-world experience, which I seek to explore through empirical research, which will be the next stage of my PhD project. And thank you very much.
Thank you so much for the presentation. It was really interesting indeed, also very detailed. I'm glad we had that extra time to the both of the speakers. It is quite reflective to see how your topic too is actually, as I mentioned earlier, tying in with what Dr. Ektar mentioned, in the sense of how this can also give or enhance climate litigation and not just internationally, but also penetrate into regional and national legislations and domestic legislations. So having said that, I'm not going to monopolize the screen time, and I'm going to open the floor for any questions or even any comments if there are any. You could either write it in the chat if you have any questions, or you could just raise your hand and feel free to speak up. Alberto, please go ahead.
Yes, thank you. Thank you very much for these presentations. I had a question for Dr. I apologize for my mispronunciation. Ekator?
That's fine.
Yeah, yes. So I'm not an expert of the topic, so forgive me my question. So from what I understand in your presentation, you say that the Court of ECOWAS could become a forum where multinational corporations could be brought into where the liability could be brought into play. And you refer to a case that is the case of Algona Resources and Sierra Leone.
Yeah.
And yeah, and could you just elaborate? Because it's what I understand is that it was about the property rights of this corporation.
Yeah.
And I just fail to see the paradox that the doctrine you quote speaks about.
All right, thank you. There have been previous cases where the ECOWAS court said that MNCs can be defendants as well. So in that case you mentioned, MNCs were the plaintiffs, were the applicants. So there have been a couple of cases where I think the CHN case and the Petro case, the ECOWAS Court of Justice said you can actually sue MNCs as well. So, but the prevailing view now is MNCs can be applicants in very rare occasions in issues relating to right to fair hearing, right to opinion, etc. So in that case, it was a compensation for the MNC that lost the mining license. So, but my view is that in terms of litigation itself, we need to look at litigation and regulation from a broader perspective. So, what is the impact of those cases? Because for people on the ground, for NGOs, is a tool of ensuring that MNCs can be held accountable. And also for scholars, sometimes we just assume that a decision is not enforceable. We don't check it on the ground. So I used to have this view that, because in the Serap case, the same perspective was taken that MNCs should be held liable. But the court said MNCs cannot be parties to that case. And Serap, the Chevron and Shell were taken off the case. At NNPC, the Nigerian National Company and Nigerian government were became part of the case. So, but that judgment itself, a lot of scholars believe that that judgment has not been enforced because the government has not set up the system. Whereas, if you go to the field, you can see some modest impacts of that judgment as well. So, NGOs, civil society groups are now using those judgments as a tool to ensure that MNCs live up to their responsibility. So, I'm taking it from a broader perspective. And also, if you look at the ECOWAS, it's one of the few tribunals that even MNCs can actually sue itself, which is also progressive in that regard. So the question is, should we make it fully progressive and say individuals, MNCs, and every legal person can sue and be sued? Because MNCs cannot get the advantage of getting justice in terms of right to property. On the other side, will start saying you cannot sue them. So the ECOWAS Court of Justice have given divergent views regarding it. So there should be a clarity on what it means. Should every legal person be sued or can be sued? Because individuals and NGOs can be sued. Because NGOs should have the same problem with MNCs, because NGOs are domestic creatures. They are creatures of domestic law. But the ECOWAS Court says NGOs can sue. So what stops MNCs? And many of these MNCs are not actually MNCs. They are part of JVAs. They are part of joint venture agreements. They are part of the NNPC and the state-owned companies. And even though you don't sue MNCs, it can actually impact on the regulation, because you're able to hold the national companies liable and accountable. Those who have an impact on the regulatory process. So I think there's more to do regarding this area. I think it's an area that needs more research and needs more work to make it it's a bit blurry at the moment. So and also recently the African Court of Human Rights, there's a recent case as well that involves the Pablo Cola case, where the African Court of Human Rights said that the Ivorian case where toxic waste was discarded into Ivorian waters, they took them to court. But in that case as well, MNCs were not held accountable. It was the government. So, but looking at it generally, there's that element of accountability. And if we go back to the Serac case initially, it's the same issue with Serac and Serap cases as well. I hope that answers your question.
Yes, thank you very
Thank
much.
you.
Thank you so much. And there's another question on the screen. I'm not sure. And please go ahead. It's better than I butcher your name. Sorry, I'm really sorry about that.
I assume it's me. My name is Okechukwu Ejims, and thank you all for a wonderful presentation. Dr. Hosa, thank you. Nice to see you again and the rest of the panel. I just wanted to make a comment in addition to accountability of MNCs. However, it's, however, the lack of I'm looking at investment treaties at the moment, looking at accountability. I just want to hear from the panel what their thoughts are. However, frustrating, there is a lack of balance between states and investors in investment agreements. And it is important to note the reasons for this imbalance, because it's not possible to create obligations such as this, climate change and environment, for investors via investment treaties. The argument is that states themselves are the parties to a particular treaty. Investors are merely third parties to the agreement. Obligations cannot be placed upon third parties to an agreement. Now, if we are looking at trying to reach a climate zero goal, if this type of legal framework is in place, that third parties such as companies cannot be, liabilities such as accountability cannot be placed on them, how do you think this will work? Do you think the movement or the as I call it, climate change goals will be achieved in this kind of legal instruments, investment treaties, not having a kind of relationship with the companies who are actively involved in carrying out investment activities under such treaties? Thank you.
Thank you. Is that for me?
Thank you so much.
Well, it's for anybody.
Okay. Okay. I'll just give some thoughts. I know Professor Matthew Upward.
Just before you begin, Dr. Ekator, I'm sorry to interrupt, but I'm happy for you to answer the question. But I was also thinking that it does tie in a little bit into what Sue mentioned, and perhaps like there are other parts of her PhD as well. So after you, if I would also like to give the floor to you, if that's okay for you to answer as well. Thank you.
Thank you very much. Sorry, to answer Dr. Squirty, I think Professor Upward has done something on the ECOWAS Supplementary Act on Investment. They argue that under the ECOWAS Court, that the ECOWAS Court can be repurposed as an investment tribunal to hold MNCs accountable, that the Petrodel case is an example of a case where two MNCs took themselves to court under the ECOWAS Court on an investment basis. So for me personally, I look at it from a perspective of African regional human rights architecture. For example, can we reconceptualize the SERAC, the SERAP, and the various East African cases, ECOWAS Court of Justice cases? For example, at the East African Court of Justice, there is currently a case relating to climate justice as well, currently ongoing. So can we reconceptualize the SERAC cases as climate justice cases? That is one way to look at it. But for investment perspective, I think there's a role for the supplementary investment protocol under the ECOWAS Court of Justice system. Over to you, Sue.
Thank you. So if I may summarize, I think the essence of this question is that in the absence of substantive obligations, is it still meaningful to consider procedural and institutional channels to kind of push in Dr. Agosa's case, MNCs, and in my case, basically states to be held accountable. So I didn't go into details in my presentation about this, but one point I made in my paper when reviewing FTA climate provisions is that these provisions could actually significantly further the objectives of the Paris Agreement. Like the prime example might be the floor provisions, which through which Paris commitments become part and parcel of free trade agreements, which provides a connecting point for using implementation enforcement tools under free trade agreements. And it is based on these observations that I set out to consider how, through non-state actor involvement mechanisms, FTA climate provisions might be operationalized to their full potential. So I think what we kind of need to be aware of is that new commitments and disciplines always come with significant political costs. And before turning to those, I think it makes sense to first evaluate the implementation and enforcement of existing provisions, like in Dr. Agosa's case, human rights litigations, and NGOs using domestic tools in domestic legal systems to see if litigation can be used as an instrument for behavior modification. And in my case, these existing seemingly unambitious FTA climate provisions that we have at hand, and the prospect for better operationalizing them for achieving compliance with climate commitments. So that is kind of my perspective.
Thank you so much. I hope that answers your question, Okichuvu. And I think we just have time for one more question or comment from anybody, if there are any.
Okay. Perhaps abuse my role as a panelist and ask Dr. Agosa 2 questions, actually.
Go ahead.
Yeah, I really enjoyed your presentation, Dr. Agosa. And so I have 2 questions. First is about, as you mentioned a lot about the legal status of MNCs in domestic sub-regional and regional litigation. My question is actually about the other side of the picture, about NGOs. So actually coming from a legal background, I was educated in China for my LLB and LLM. So in China, up until 2014, NGOs do not have a legitimate legal status in litigation against multilateral like corporations, basically polluters, because they are not considered to have a legitimate interest in these domestic cases. So I was wondering if NGOs have encountered difficulties for being recognized as a litigant or complainant in your case. And the second question is about, I think you meant, I think the gist of your argument is kind of like non-state actor in litigation opens up a space in domestic judiciary system to push multilateral MNCs to be held accountable. And I was wondering, what's your thoughts on the utility or the effectiveness of the conceptual framework of legal status on the international plane, like the conceptual framework relying on legal status on these hard rights and obligations? How relevant is it in the international sphere in terms of like international litigation? Because we know like currently actually most climate litigation are happening on the domestic level. And do you think there might be more innovative solutions, for example, soft law, not regarding on these harder frameworks, you know, to be used on the international plane to push the momentum from domestic to the international? Thank you.
Okay. Thank you very much for your question. In terms of NGOs and access and litigation, as I mentioned in my presentation, ordinarily in Nigeria, environmental NGOs had no legal standard to institute cases on behalf of communities. So they said it must be directly impacted, it must have sufficient interest before you can institute environmental matters. But in 2019, Nigerian Supreme Court liberalized local standard for environmental NGOs in the Center for Air Pollution case and NMPC Nigeria. So in that case, an environmental NGO sued on behalf of a community that was negatively impacted by environmental degradation arising from an NNPC, the state-owned corporation. So they lost at the Federal High Court, they lost at the Court of Appeal. When they got to the Supreme Court said environmental NGOs in Nigeria do have the legal standard to bring cases on behalf of the environment and people who have been negatively impacted. So on that part, so the local standard in Nigeria has been liberalized. But the problem is, if tomorrow the Supreme Court can also make a further decision that will restrict the remit of the local standard given to NGOs. So people have said that the Nigerian government should basically make a law that explicitly states that local environmental NGOs do have local standard. That would make it clearer. But as it is now, environmental NGOs have local standard to institute legal cases. From the ECOWAS Court of Justice case, NGOs do have legal standing to institute cases at the ECOWAS Court of Justice. There's no issue with that. Then, in terms of the effectiveness of the legal status of that rights, so I think for me, for climate issues, I think there has to be a plethora of strategies. There's no one way to tackle the scourge of climate litigation. Yes, we can use international mechanisms, we can use domestic mechanisms, we can use soft law. They all work together in tandem. So because I've done some stuff on climate litigation, if we are going to define climate litigation, for example, there's this global north perspective that climate litigation means a case that involves direct, explicit connection to climate litigation. Whereas from the global north-south perspective, environmental justice cases can be reconceptualized as climate litigation. So for example, the Center for Air Pollution case that I alluded to, I've basically reconceptualized that case as the climate litigation case. So climate litigation depends who you are talking to. What are they looking at? Also, from a climate justice perspective at the international level, does the Paris Agreement promote climate justice? Yes and no. If you look at the preamble of the Paris Agreement, it alludes to human rights and climate justice. It mentions it, but we all know that preambles are not enforceable. But in that regard, however, on the basis of, but notwithstanding, the Brazilian Supreme Court has held that the Paris Agreement is a human rights treaty, and the Paris Agreement can be used as a tool to promote climate litigation and climate action. You can look at the Philippines case, or the tribunal that looked at the various reports on MNCs to hold MNCs accountable. That is one. You can look at the various cases from Latin America, even in just transition litigation. So there are lots of cases taking place outside of what we know in Western academia. So some of the leading cases of climate litigation are actually from Pakistan, the Legara case. The first climate litigation case is from Nigeria, the Benue case. So I think for then the international human rights mechanism, if you look at the last report by A.M. Fry, the Special Rapporteur on Human Rights and the Environment in the context of climate change, he alludes to the fact that climate change is environmental, is human rights. So if you say someone has got human rights, that same tool that you use to promote human rights can be used to promote climate justice, climate action. Your right to environment, your right to life, your right to food, those same tools can also be used to promote climate action. For example, some countries do have climate provisions in their constitutions now. So can we use existing right to environment provisions to promote climate litigation, to promote climate action? Yes. I think that's my answer. I think we need to look at it from a very diverse perspective. There's no one way, because climate change affects everybody, and the countries have got, not every country has got the right adaptation tools, and the poorer countries are also victims of climate vulnerability. So I think if we look at it from a broader perspective, international law, soft law, Ruggie principle, and domestic law at the international, national, even the listed advisory opinion by the ICJ, potentially, that is another option. So there's so many tools that we can use. I don't know if that answers your question, or I'm just rambling about. Thank you.
Thank you so much, Dr. Egusa. Just to let everyone know, I don't know if everyone can read the chat, but Theodora has also mentioned that she thanks everyone for the presentation and discussion, and her point was climate litigation can rely on human rights law and by extension constitutional and tort law, etc. Lawyers in civil society are getting increasingly creative, and a useful database for climate litigation is that of the LSE Grantham Institute. And if I may add, to abuse my power in the last bit and to sum this up, is that this as everyone knows, is there on the Seven Center database as well. And at BIICL, we are actually also looking at something what Dr. Ektor has been discussing about a role of NGOs and just like what is the climate litigation or environmental litigation scenario in 17 different jurisdictions. And I think because this was mentioned, and I think this is very relevant, is that we are trying to break the barriers of what climate litigation is traditionally accepted or acknowledged or looked into. And then as he very rightly mentioned, like it goes beyond just like, climate being the main issue in a case, but it can go into, as mentioned in the chat, also can go into domestic other legal provisions, not only including constitutional and torts, but also into frauds, companies, and financial laws. And through those mechanism bringing in not just MNCs, as rightly mentioned, but also state actors and state authorities and boards, like for example, the new pollution boards, etc., into for transparency. And I think that there is a lot of litigation in the global south, as Dr. Ektor mentioned earlier, but also from traditionally what climate litigation was defined. And it goes back to litigation in asbestos and the tobacco cases that we can see in Brazil and other jurisdictions as well. So I think just to sum this up and let everyone go for a break, I think it is safe to say that even not just like definitely after the Paris Agreement, after COP21, but even before that, I think non-state actors, NGOs and MNCs in their unique positions play an important role in reducing these emissions, and I think it would also support at the same time bring in more transparency in government policies and legislations to cut down emissions and to if at all we do get back on track of let alone 1.5, but at least 2 degrees in the current situation that we are in. So I think I'm going to wrap that up over here, and I'm going to stop the recording.